Yeah, Justices, please remember to unmute before you give your hand downs.
Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Oh, good morning. The court has cases to hand down today. CR 11-331. Ricky R. Anderson versus Dexter Payne, Director, Arkansas Department of Correction, from Washington County Circuit Court. Petitioner's pro se motion to recall mandate, petition for writ of habeas corpus, and motion for joinder of claims, all denied. Justice Webb concurs.
CV-20-562, John Thurston in his official capacity as Secretary of State, and Leslie Rutledge in her official capacity as Arkansas Attorney General versus Safe Surgery Arkansas, a ballot question committee, and Dr. Lori Barber individually and on behalf of Safe Surgery Arkansas. From Pulaski County Circuit Court, 9th Division, affirmed.
CV-2078, Leroy Calhoun versus Area Agency on Aging of Southeast Arkansas. From the Arkansas Workers' Compensation Commission, reversed and remanded. Court of Appeals opinion vacated. Justices Wood, Womack, and Webb dissent.
CR 19-824, Tara Cole versus State of Arkansas, from Drew County Circuit Court, affirmed. Court of Appeals opinion vacated. Justice Baker concurs and Justice Wynn dissents.
Okay, will the clerk please read the submissions?
Pardon me. Our oral argument this morning will be CV-20-421, Sherry Tomey as guardian of the estate of a minor versus Southern Farm Bureau Casualty Insurance Company and others. This is an original action on certification from the United States District Court for the Eastern District of Arkansas. Also being submitted this morning are 3 other appeals. Criminal case 20-106, Sean Collins versus the state of Arkansas from White Circuit. CR 20-597, Emmett Riley versus the state from Drew Circuit, and civil case 19-625, Charles Simon-Yates versus Deborah Simon-Yates from Benton Circuit. In addition to those appeals, there are 11 other various motions and petitions being submitted to the court today.
Okay, thank you. The case for oral argument is CV 20-421, Tomey versus Southern Farm Bureau Casualty Insurance Company and others. Justice Wynn is unable to participate in the oral argument, but he will be participating in deciding the case. And at this time, the court will recognize the appellant's counsel. Mr. Reeves. Mr. Reed.
Thank you. May it please the court. My name is Tim Reed, and I represent the petitioner, Ms. Sherry Tomey, who is the grandmother and legal guardian of Novaline Kent. I'd like to reserve 5 minutes of rebuttal. I see that has been done. Thank you. Petitioner appreciates the opportunity to address the court and this certified question of law, which is whether the state of Arkansas recognizes an exception to the parental immunity doctrine when a direct action suit against a motor vehicle liability insurance carrier for underinsured motorist coverage is at issue, and when underinsured motorist benefits are the damages requested. Now, this boils down to whether there is a reason to distinguish uninsured motorist coverage from underinsured motorist coverage when applying the exception to parental immunity as announced in Fields versus Southern Farm Bureau back in 2002. Now, that case was, of course, decided on facts giving rise to an uninsured motorist claim, where Farm Bureau unsuccessfully argued that the injured minor was not legally entitled to collect the uninsured motorist benefit because his mother was driving, and the parental immunity doctrine bars an unemancipated minor from asserting a negligence claim against his parent. Note the language legally entitled to collect, because we have the same legal issue in this case. Now, the facts giving rise to an uninsured motorist claim differ from the facts giving rise to an underinsured motorist claim, but these are two paths that converge on the same destination, and that is a claim directly against the motor vehicle liability insurance carrier, not a negligence claim against a parent. Now, Nova's case back in April 2016, when she had just turned 3 years old, she was riding in a van driven by her mother, Christina Buchanan, which was owned by a third party, Anthony Ray. Nova was seated behind her mother, who veered into the oncoming traffic lane and collided with an 18-wheeler head on. The collision was devastating and unfortunately killed Ms. Buchanan. Nova suffered a debilitating brain injury and was airlifted from the scene in critical condition. Mr. Ray's van was insured by the Hartford with a third-party liability insurance policy in the amount of $25,000. Given Nova's irrefutable and immense damages, the Hartford offered to pay that $25,000 policy in exchange for a release of claims against Ms. Buchanan and her estate and Mr. Ray. Now, the payment and exhaustion of that liability policy triggered the $50,000 underinsured motorist coverage purchased by Ms. Buchanan from respondent. Ms. Buchanan, of course, purchased that insurance benefit to protect her family. Petitioner asserted a claim for that coverage. Respondent denied the claim, asserting, just as it did in Fields, that Nova is not legally entitled to recover because her mother was driving, and the parental immunity doctrine bars that claim. Uninsured and underinsured claims are indistinguishable in this setting because both claims sound in contract and are directly against the insurance company, not a parent. Public policy analysis in Fields is therefore directly on point. In Fields, with respect to public policy, the court stated, "We first see no damage to the family unit where the insurance company is the true adversary." Note the term true adversary appears to be inspired by the following excerpt.
Counsel,
Liability. Yes.
can I, before we go into the parental, could I ask you a question of whether, if you could clear up whether the release against Miss Buchanan, was that resolved at the district court about the release? If your client signed a waiver against and released all claims against Miss Buchanan and her estate, that did not apply to the being able to sue Miss Buchanan here, that we would have this certified question properly in front of us?
It would apply. In fact, if Miss Buchanan's estate was to be named in a case, it would be dismissed upon request because there is no claim for negligence against that estate. That claim has been released. This case is directly against respondent. So mother and mother's estate is not a necessary party here.
Okay. But we're deciding parental immunity and whether you can sue the mother, but they've actually signed a release saying they can't sue the mother.
Exactly. That a lawsuit could not be brought against Miss Buchanan's estate at this point. The lawsuit would be released ultimately, or dismissed, excuse me. But this is a contract claim against Farm Bureau. Farm Bureau is arguing that the phrase legally entitled to recover or collect means that they can assert an affirmative defense based on a claim against Nova's mother, when really this claim is against Farm Bureau. The liability claim has been dispensed with. It has been released. And in all underinsured motorist cases, To my knowledge, that's going to be the case. The tortfeasor has been released. That triggers the underinsured motorist coverage, and the contract between the the covered person and the liability insurance carrier. It becomes a contract matter at that point. Does that satisfy? I agree.
Well, you answered my question, so I'll let you continue with the argument. Thank you, though.
Okay, thank you. With respect to damage to the family unit, the court in Fields was most persuaded by this quote here. Liability insurance impersonalizes the suit and negates the possible disruption of family harmony by easing the financial repercussions of the accident. In short, when insurance is involved, the action between parent and child is not truly adversarial, but both parties seek recovery from the insurance carrier to create a fund for the child's medical care and support without depleting the family's other assets. Note that this quote, which was pulled from the Williams and Sorensen courts out of Delaware and Massachusetts, respectively, refers to an action between parent and child. The court then stated, we can readily understand how an action against a liability insurance carrier might ease the financial crunch caused by a car accident rather than becoming the source of family disharmony. So notice how the court shifted from an action between parent and child to an action against an insurance company, citing R.B. Ard out of Florida in support of that proposition. But the Ard case was not an action directly against an insurance company. Williams, Sorensen, and Ard were cases between parent and child with the parent as a named defendant. So what we see here is the court adopting certain language and adapting these analyses from cases between parent and child for use in actions like the one at bar, which are directly against the insurance company and the true adversary. And so as a practical matter, with these claims against the insurer, the insurance company is not only the true adversary, but generally the sole adversary. As we discussed, the parent has been released at this point. With respect to fraud and collusion, the court concluded that we are convinced that the judicial process and investigation by the carrier itself will stem the potential for abuse. And of course, when a parent dies, as in this accident, there's very likely no fraud or collusion between the parent and child. Regarding the adequacy of criminal sanctions to punish parents for acts that are arguably criminal, of course, Arkansas has already qualified the parental immunity rule and accepted intentional torts by a parent. So that in sum is the public policy analysis in Fields. And it's directly on point here.
Counsel?
Yes, ma'am.
How would you respond to, and you bring up the public policy, whether we should leave the policy decisions to the legislature on these issues versus the court?
Well, in American jurisprudence, parental immunity came about first in 1891 in Mississippi in the Hewlett case. That was adopted by the majority of jurisdictions judicially, as it was in Arkansas in the Rambo case of 1938. It's always been a doctrine of judicial creation as far as Arkansas goes. What you've seen across other jurisdictions in some cases is the legislature has stepped in because they felt like the doctrine resulted in injustices. So for instance, Maryland, about the same time Fields was decided, its legislature decided, this is unfair. We're going to allow suits against parents in negligent operation of motor vehicle cases up to the extent of the liability coverage, which is really a step farther than what we're discussing today. Today, we're discussing really the indistinguishable nature of uninsured and underinsured coverages and claims, which are both against the insurance company. There is a third type of case where, and that's really not what petitioner's asking for in this case, but ultimately this court may have to consider whether or not a parent should be named in a suit in that third type of case. So you've got a third party liability case, uninsured cases, and underinsured motorist cases. And so largely that's what you've seen with legislatures across the states is they'll intervene because they don't believe the doctrine is fair. And of course, in Arkansas, we've created exceptions to the parental immunity doctrine. It was judicially adopted, and it's been modified judicially ever since. And of course, you know, in 57, in the Leach case, an interspousal immunity case, that court noted, you know, that the legislature had not stepped in with respect to interspousal immunity. Well, the same thing really applies here. It seems that the legislature is content with what the court has done. In any event, you know, Farm Bureau argued the same thing in Fields in 2002, and the court disagreed, noting what I just noted.
Thank you.
Thank you. To demonstrate the fact that there is no relevant distinction between uninsured and underinsured for purposes of this analysis, consider the following. In the insurance policy at issue, the uninsured motorist provision, which can be found at addendum 31, reads in relevant part, we will pay damages you are legally entitled to collect from an owner or driver of an uninsured auto for bodily injury suffered by you caused by an accident arising out of the operation, maintenance, or use of an uninsured auto. So an uninsured motorist checklist would look like this. There's a covered person, bodily injury caused by an accident arising out of the ownership, maintenance, or use of an uninsured auto, and you must be legally entitled to connect. So recall that in Fields, Farm Bureau argued that the injured minor was not legally entitled to collect because his mother was driving and the parental immunity doctrine applied. This court disagreed, effectively interpreting that language, legally entitled to collect, as providing no such bar in a direct action against Farm Bureau. So in short, the injured minor in Fields was a covered person. He was insured. He was under the policy. His bodily injury was caused by an accident arising out of the ownership, maintenance, or use of an uninsured auto. And the final question was he legally entitled to collect? And the answer was yes. So if we look at the policy at issue here with respect to underinsured motorist coverage, that's at addendum 34. That provision states, we will pay damages for bodily injury, which a covered person is legally entitled to recover from the owner or operator of an underinsured auto. The bodily injury must be caused by an accident arising out of the ownership, maintenance, or use of the underinsured auto. And then there's an additional prong here. We will pay under this coverage only after the limits of liability under any applicable bodily injury liability bonds or policies have been exhausted by payment of judgment or settlements. So the underinsured checklist looks like this. You must be a covered person. Bodily injury must be caused by an accident arising out of the ownership, maintenance, or use of an underinsured auto. The limits of the third-party liability policy must be exhausted. And then we get to that final inquiry, the same inquiry. You must be legally entitled to recover. So here, Nova checks all the boxes for her underinsured motorist claim. She is a covered person. Her bodily injury was caused by an accident arising out of the ownership, maintenance, or use of an underinsured auto. The limits of the third-party liability policy have been exhausted. So the remaining question is she legally entitled to recover? The answer must be the same as it was in Fields. The legal issue is the same. Therefore, she should be legally entitled to recover in this case directly against Farm Bureau. So this too is a direct breach of contract action. It's not a negligence case against a parent. I'll reserve the rest of my time for rebuttal if there are no more questions.
Okay, thank you. The court will now recognize the appellee, Mr. Jones. Still on mute.
Thank you, Mr. Chief Justice. And members of the court, it's my distinguished honor to appear before you today on this matter on behalf of the Southern Farm Bureau Casualty Insurance Company. As you know, Southern Farm Bureau Casualty Insurance Company, I'll just refer to them as Farm Bureau throughout this argument, just for brevity's sake. is the respondent in this action. On the certified question before you, which I believe Mr. Reed stated was whether Arkansas recognizes an exception to the parental immunity doctrine when a direct action suit against a motor vehicle liability insurance carrier for underinsured motorist coverages is at issue, and when underinsured motorist benefits are the damages requested. And I think that it's very important for us to focus on the question that's presented to the court by the federal district court of the Eastern District of Arkansas. And that is, does Arkansas recognize an exception where there's recognize an exception to the parental immunity doctrine where the damages sought are underinsured motorist coverages? And I think that question was answered in Fields. And in Fields, 2002, this court held very narrowly that it would recognize an exception to the parental immunity doctrine where a direct action suit against a motor vehicle liability insurance carrier for uninsured motorist coverages is at issue, and when insurance benefits are the damages requested. And the court followed that statement by specifically stating the exception that we carve out by this opinion is limited to those circumstances. In all other matters where the exceptions have not been made in our case law, we retain the doctrine. And I believe this court, in a prior certified question in 2016, I believe the case was Columbia Insurance versus Cinark. This court even stated that, in answering these certified questions, it's important, and it's important to, in regards to stare decisis, that there's a strong presumption regarding the validity of prior decisions, and it's necessary as a matter of public policy to uphold those previous decisions. And I believe that was Justice Hudson that said that. And
Well, Counselor, to respond to Fields being so limiting, I guess my question would be, maybe that was just good jurisprudence in that the court was addressing the question presented and being and tightly writing our opinions is something that oftentimes we strive to do, to keep our analysis focused solely on the facts before us rather than anticipating what's to come, because that generally leads to assumptions that shouldn't be made. So how do we distinguish that?
well, I think that's what's happening here, Justice Hudson, and I appreciate the question. In fact, I believe the court at that time could have, I believe the court in the past in Spears even had an opportunity before it, but determined that, of course, that the question wasn't preserved properly for the court to make that decision at the time. But the court made the caveat in Spears that it did intend to revisit the doctrine at a future date, and it did so in Fields. And then, of course, in Fields, there was a question presented: what do we abrogate the doctrine in toto? Because that was the question. That was one argument that was presented to the court. The appellate in Fields wanted the doctrine to be completely abolished, or in the alternative, to be narrowly for an exception to be carved narrowly in regards to uninsured motorist coverage. The court at that time, if we're going to address that uninsured and underinsured motorist coverages are indistinguishable, I would submit that those coverages were both in existence at the time of the decision in Fields, and the court very well could have said, we're carving this limited exception out to this doctrine, and uninsured motorist coverages and underinsured motorist coverages, they're indistinguishable. So we're going to carve an exception out for these two coverages, and the court did not. And in fact, later, an argument was made before the court, and I believe it was in Greenwood versus Anderson in 2009. The appellant asked the courts again to revisit the doctrine where liability insurance is involved, which, as Mr. Reed informed the court earlier, of course, there's three different, I guess for the purposes of this argument, there are three types of coverages that you look at in a direct action in a liability insurance context, and that is liability coverage, underinsured motorist coverage, and uninsured motorist coverage. And in Greenwood, the appellates asked the court in the alternative to abrogate the doctrine where liability insurance is the damages sought. And of course, again, the issue wasn't properly preserved for the court, and the court declined to address it at that time, just as in Spears. However, in Greenwood, the court did not state, as it did in Spears, that it intended to revisit that issue. And I think the court could have, and it didn't. And that's because it noted in that Greenwood decision that there are two exceptions that were carved out for parental immunity that the court recognizes, and that is an intentional or willful tort, and when a suit is a direct action against an insurer and the damages sought are uninsured motorist coverages. And I think there's a very good reason for that. And I think we can kind of get into that if we look at the court's decisions or the court's opinion in Verdier. Verdier, I don't recall if Mr. Reed touched on this, but in Verdier, the parental immunity doctrine was again brought before the court. I think this followed Fields in 2005, so it was prior to Greenwood, and it actually involved a claim by a minor against a parent. And in this particular case, the minor child was riding on the back of a lawnmower, and I believe that the minor somehow fell off the lawnmower and the father ran over the minor. And of course, the minor now is injured by the father, has a potential claim. And I believe the minor tried to make a claim under the homeowner's policy. And of course, we can distinguish, maybe we could distinguish that case from Fields on the fact that we're dealing with the homeowner's policy versus a automobile liability insurance policy. And I think they do distinguish between those two coverages in Verdier. But there's an important point in Verdier that I think that is important for the court to note. And that is the majority opinion discusses that in the context of homeowners insurance policies, it would create issues if the court were to carve out an exception to the parental immunity in regards to those policies, because those policies aren't required to be carried by the general public as motor insurance, automobile insurance is required. However, the court did note that if it were to carve out such an exception and allow suits to be brought against parents under their homeowners insurance policy, the result would be to create, and this is, I'm quoting from the opinion, the result would be to create separate benefits and burdens for those who insured and those who are not. Now, that's important if we're going to try to distinguish between uninsured and underinsured motorist coverage. And here's why. As Mr. Reed pointed out, I think he said, there's three points you have to cover, 3 boxes you have to check for uninsured motorist coverage. That is, you have to have a covered person, a bodily injury, and if that bodily injury arises out of the operation or use or maintenance of an uninsured vehicle. In those boxes, none of those boxes require a minor to directly file a suit against or file a suit against his parent. But when Mr. Reed discussed underinsured motorist coverage in the boxes you have to check, we talk about the same things: covered person, a bodily injury arising out of the use, operation, use, or maintenance of an underinsured motor vehicle. I'm sorry, I guess I missed legally entitled in the last one. Of course, that's a big issue here. But of course, one major distinction between these two types of coverages is the conditions precedent, and that is underinsured motorist coverage requires an additional box, and that is that there has to be underlying liability limits that are exhausted, and that's not required for uninsured motorist coverage. And you might wonder, why is that important? Well, here's why. As we stand here today, and I believe Mr. Reed conceded to this fact in his argument, that Arkansas does not recognize an exception to parental immunity where liability insurance are the damages sought. And in that case, if, for example, in our case, we have the Hartford, in this direct case with Ms. Tomey versus Farm Bureau, we have the Hartford, who's the underlying liability insurance carrier. Ms. Kent made a claim under that liability policy, and the Hartford paid that claim on behalf of Ms. of Miss Buchanan, who's our mother, and the van owner. However, the Hartford could have, in another example, Hartford could have said, well, respectfully, Ms. Kent, we don't believe you're legally entitled to recover from the operator of the van because she's your mother. And at that point, maybe Ms. Kent has an uninsured motorist claim, arguably. I don't know what her policy says. But in this instance, the Hartford, for whatever reason, whether it was ignorance of Arkansas law or I don't know what considerations they used when they determined to pay out the policy limits for her. But I think that kind of runs afoul of Verdier. If this court were to expand the exception to include underinsured motorist claims, I think we would end up with I think the result would be to create separate benefits and burdens for those who are paid liability limits, exhaust liability limits under a policy, and those who don't. For example, if like I said, if Hartford said, well, you're not legally entitled to recover from your mother, then we're not going to pay it. And at that point, there's no underinsured motorist coverage because there's no underlying liability limits that have been exhausted. So that's a very important reason to distinguish between those two types of coverages.
Counsel, what would be your response to the fact that the mother being deceased, we have, the reasoning for parental immunity going back to really Rambo was this preservation of family harmony and the prevention of collusion and fraud concerns. And that has been really the court's sort of long-standing. But I think in Atwood, we talked about that when the parent, the living parent, it's not against them and that relationship has been terminated by death, really those policies have lost their force. And that's the case here. What would be your response to that?
That's a good question, Justice Wood. And I don't disagree that those policy reasons might not apply in this particular scenario. Obviously, adequacy of criminal sanctions and upholding parental authority, those aren't necessarily going to apply in an automobile accident context. But in family harmony, when there's a parent who's deceased, of course, as in the underlying facts of this case, might not necessarily apply. But there are thousands and thousands of claims, that are made where the at-fault driver is not necessarily deceased in the accident. And, I think if the court went so far, this is well beyond the certified question, but I think if the court went so far as to, in the future, expand the doctrine to expand the exception to exclude the parental immunity doctrine against claims for liability coverage, I believe you would start having some of those issues. I think those policy reasons would become irrelevant, particularly family harmony. One thing that comes to mind, I would think in that context would be, for example, if you have a dad driving and he's got two kids in the back seat and dad gets in a wreck and dad is determined to be at fault. Obviously, the two kids as passengers would have a claim against the dad if they were able to, if there was an exception for the children to seek those liability coverages. But the issues would arise in, number one, if dad's still alive, those children would have to seek medical treatment. And of course, who incurs those medical costs? The minors don't. It will be the parents and the father. So the tortfeasor in that scenario is the one incurring medical costs. And on top of that, in that context, if the father's alive or the at-fault parent's alive, they're the parent and guardian of the child. They would have to approve the settlement if there was a settlement. So it's a strange nebulous because in those contexts, the parent has a pecuniary interest in the outcome, and that's not something you typically have when you have a claim against a tortfeasor. And I think that, and again, I realize that's a little outside of the question here. But I do think it's very important for this court to, if we're going to consider that there's a reason to distinguish between the two types of coverages. Of course, it's my position that there is plenty of precedent available for the court to stand on here, and it is lined out specifically in Fields. And I think the court was very clear in its limitation of its holding. However, if we're going to distinguish between the two types of coverages to determine whether or not the field exception should apply, I think it's very important to look at that one check mark that we were talking about, that Mr. Reed talked about, and that is whether or not the underlying liability limits have been exhausted. And I just want to reiterate in my last few minutes here that if that were to be the expanded exception, that we would have a scenario where the underinsured motorist carrier would be bound by the liability carrier's decision, and that is whether or not the liability carrier decides that they're going to waive their defenses or waive their parental immunity defense. And I can't think of a scenario where a person or a company is where a person or company can waive the defenses of a third party. And I think that's what we would end up with here if the court were to decide to include underinsured motorist coverage in its exceptions enumerated in Fields. And if the court doesn't have any other questions, I will pass my time to Mr. Reed.
Respondent just noted waiving defenses on behalf of a third party, but respondent is asserting parental immunity on behalf of a deceased mother here. And even if Ms. Buchanan had survived, she is not a party to this lawsuit, nor was the mother in Fields. And that's really the issue here. This is a direct action against an insurance company. And respondent makes these arguments about inconsistent outcomes. Well, the Hartford didn't have to do this, and it did that. We don't know how many insurance companies might have paid this in the past. Hartford could read Fields the way I read Fields. It's all about negligent operation of a motor vehicle. The cases that Fields cites, that is really the issue. Now, Justice Hudson is correct that case was decided on its facts. There was no need to explore an underinsured motorist claim under the facts of Fields. As we discussed, Justice Wood discussed, and whether or not the legislature should get involved, this court has always defined the contours of the parental immunity doctrine. So, and it does so carefully, and rightfully so. Petitioner is not here to encourage abrogation of the doctrine. This is all about negligent operation of motor vehicles as an overarching issue and theme and exception, but really under the facts of this case, where the policy analysis is precisely the same. So, and in fact, what respondent has done here is really admit petitioner's case when it says Hartford and other similarly situated motor vehicle liability insurers are entitled to assert the parental immunity doctrine. And in those instances, the injured minor would not be entitled to underinsured motorist benefits. Well, then the converse is true. When they do pay, then the injured minor is entitled to underinsured motorist benefits. And so the term respondent used was apt, conditions precedent. And yes, there's a third prong, exhausting the liability limits. What the liability insurance carrier chooses to do is what it does. And this is arguably sort of the cart before the horse. In an ideal world, as far as these types of exceptions go, this might have been decided in Spears in '99. Unfortunately, the appellant didn't provide the court with enough authority and didn't specifically didn't plead the existence of liability insurance coverage. If you read that opinion, it appears very clearly that the Spears Court was prepared to create a negligent operation of a motor vehicle type of exception that would encompass all three types of coverage: liability, uninsured, and underinsured. It simply didn't have what it needed to make that decision. And of course, then Fields was decided on its facts. Respondent is flat out wrong about Greenwood. That issue was not preserved on appeal, so the court simply didn't address it. And the Verdier case actually strengthens petitioner's position. The court was careful to distinguish homeowners insurance from automobile insurance. So again, we're not saying that, homeowners insurance or any other type of insurance should be involved, or there should be an exception there. And the reason is, if you look at comment K of restatement 8, section 895, restatement section of torts, 895G, comment K, which was cited in Verdier, that this is against a complete rejection of the doctrine. For activities central to the parent-child relationship, particularly within the home itself, there's some relaxation of the stricter standard of conduct applied in dealing with third persons. A child thoughtlessly leaves his skates in a hallway and the parent trips over them, or slides on them and falls, or a parent delays fixing a slightly broken step, or calling a carpenter to do it and the child falls as a result. Those occurrences are normally regarded as commonplace incidents in family life and usually treated as accidents rather than the basis for imposing legal liability. Whereas negligent operation of a motor vehicle is completely different than that. Supervisory prerogatives and family harmony, you essentially, I don't want to say you check those at the car door, but once you get into an automobile, you and your children are part of the motoring public, traveling public. Negligent operation of a motor vehicle pertains to the rules of the road, not how you supervise and raise your children in the home. That's why that should be distinguished. And the Verdier court did a fine job of that, actually bolstering petitioner's stance here. So as regarding stare decisis, again, petitioner is not asking for a different rule altogether to be fashioned here. This precedent exists for a direct action against. I think I've run out of time. I'm sorry.
Any questions? Okay, if not, that will conclude the oral argument then. Thank you, counselors.
Thank you.
And court will be adjourned.